15. El día de hoy contamos con la presencia de una figura de reconocido prestigio internacional y quien tiene un papel muy importante en bioética dentro del Consejo de Europa. La doctora Laurence Lwoff dirige el Comité de Bioética del Consejo de Europa y con gran agrado pues le damos la más cordial bienvenida a las instalaciones de la Comisión Nacional de Bioética. El tema que desde luego abordará el día de hoy la doctora Laurence Lwoff será sobre los derechos humanos y biomedicina, es decir, el Convenio de Oviedo, un referente ya a nivel global. Y para nosotros es muy importante la visita de la doctora Lwoff porque México está haciendo pues todo el esfuerzo y viendo hacia que nos adheramos al Convenio de Oviedo. La doctora Lwoff tiene un currículum muy impresionante y que desde luego yo podría darle lectura, pero desde luego pues sus estudios en la maestría que tiene en ciencias, en fisiología reproductiva de la Universidad de la Sorbona, podría seguirme destacando más, pero a mí me gustaría más darle la palabra a la doctora Laurence Lwoff para que ella nos platicara de pues sus estudios y por otro lado cómo con esa perspectiva que tiene en agronomía, como mencionaba yo, en fisiología reproductiva, también la tiene pues un doctorado en biología molecular y para nosotros es mejor porque con este bagaje multidisciplinario hoy está dirigiendo una de las áreas más importantes del Consejo de Europa, que es la bioética. Y la bioética, pues la hemos descrito, la hemos visto como una multidisciplina, la multidisciplina del siglo XXI, y desde luego pedirle a Laurence que nos platique why you are in bioethics with such an impressionant curriculum, CV. Thank you, Laurence, for coming.
Well, thank you very much, Dr. Manuel Cristo Chavez, and I'd like to thank you and through you all the team for this invitation. It's really a pleasure and an honor for me to be here today. I want to take this opportunity also to acknowledge the extremely good collaboration we have with Mexico as a state observer in the Council of Europe and represented by you, Dr. Manuel Cristo Chavez, and the involvement of the Mexican delegation in the work of the Council of Europe, because as you know, Mexico is an observer in the Council of Europe, so as such has the opportunity to contribute to all the discussion on bioethics and has done so for quite many years now. And it's really appreciated, I think, by all the member states and all the members of the Intergovernmental Committee in Bioethics. Now, you asked me a specific questions, which is really personal, so I will reply on my own capacity and on individual. I'm a scientist by education, I could say so, to summarize the different my cursus, which is not always straightforward from a first sight, and I've always been interested in the interface between science and the public. And I think that bioethical issue or societal issue, which concerns all of us as citizens. Well, as a scientist, I felt particularly concerned, but I think this is equally true for lawyers, for philosophers, for sociologists, for anthropologists, for any citizens. So for me, it has always been an interest, and when I knew that the Council of Europe was starting something in bioethics, I immediately was willing to join that work, and I was happy enough to get this opportunity. But I must say that the team I'm heading now is a multidisciplinary team. Well, not to the extent that bioethics is multidisciplinary, because it's mainly composed of biologists and lawyers. But we benefit from this multidisciplinarity in the committee itself. If you look at the delegations of the member states, you find all the different fields concerned, including philosophy, anthropology, sociology. And this is also reflected on the ad hoc groups that are set up to address specific issue. So I don't want to prolong too much, but for me it was natural to go in bioethics. And I must say on a personal basis that I found really privileged to work in this field because, well, yes, it's good to contribute to something, but it's also good to learn and to work in multidisciplinary team, to work with people from 47 countries with different background is really a privilege that make you think differently, and it's, well, enriching yourself. I think this is an important point. That's a good motivation for me, certainly, in this area. Now, if I may start this presentation, so my objective will be to give you an overview of the most important instrument elaborated by the Council of Europe relevant to the bioethics field, which is the Oviedo Convention. But I think that before doing so, it's always good to give some reminder about the Council of Europe. I won't do it very long, but just briefly to remind that this is the, sorry, I think I'm a little bit too sensitive. This is the first European intergovernmental organizations which was set up in 1949, which is distinct from the European Union, which was set up a few years later in 1954. It has 47 member states, which include the 28 member states of the European Union, but extends more toward the east, including Russia, Azerbaijan, Armenia, and the north with Iceland, just to give you a few examples. And it has observer states, which are non-European states, which are invited to participate in all Council of Europe activities. And Mexico is one of those states. To the list that you see in the slides should be added Israel and Australia when it comes to bioethics, because they are also invited to attend and to participate in the work in bioethics. It's based in Strasbourg, and its main role is strengthening human rights, democracy and rule of law in the member states. And how it does so mainly by developing standards, but also following their implementation through monitoring process and trying to facilitate their implementation of the principles adopted in this instrument by cooperation activities which are tailored to the needs of the different states concerned. The objective of the Council of Europe activity in bioethics is really related to the first pillar of the activity of the Council of Europe, which is the protection of human rights. And it is to ensure the protection of those rights in the particular field of biology and medicine. This is a pioneering work. It started already in the 80s and continued to be unique at international level by its human rights approach. It has become, as I will try to illustrate in my presentations, a reference, well, at European level as well as global level. I should have started by national level because, as you would see, there is an important impact of that convention also at national level. So the Convention on Human Rights and Biomedicine, which has a longer name, as you can see in these slides, but is known more often as the Oviedo Convention because it was open for signature in April 1997 in Oviedo in Spain. It has been signed by 31 countries and ratified by 21 countries so far. For those who are not familiar with that, I think signature is a sort of a formal acknowledgement by a country of the value of a legal instrument, but it's not committing that country to implement the conventions. Whereas ratification is actually a move that is actually committing. It's a formal step that committing the country concerned to implement the principle of the convention. There is no obligation of means, but an obligation of result when you ratify the convention. And as you say, I put in between quotes something which was actually referred to on the occasion of the celebration of the 10th anniversary of the entry into force of that convention in 2009, that this convention represents both an achievement and a starting point. So I just want to give a little bit of history, not specifically on the Oviedo Convention, but in the context within which this was developed. So after the Second World War, the treaty elaborated, mainly governed the relation between the states and their citizens. Just in the human rights field, the reference is the Universal Declaration of Human Rights, and then I have presented some examples of other instruments that are derived from this or closely linked to that declaration. The idea was to contribute to a coherent system of principle focusing on the protection of individual rights. But at one point it was felt that there was differences in the member state, in the country, in the way to implement those principles. And it was felt that this kind of formal acknowledgement of universal principle might be insufficient to protect the values on which there was agreement. So there was a search for new mechanisms to ensure respect of those principles. And the response, or one of the responses to this concern, was the development of cooperations, regional cooperations between states. Hence the creation or establishment of the Council of Europe in 1949 and the European Union in 1954, with different working methods, different objectives, but I think they are marking this wish to reinforce the cooperation between the states for those two organizations. So in the Council of Europe, a key instrument is the European Convention on Human Rights, which was adopted in 1950. And you see in the preamble that it stated that the idea was to take the first steps for the collective enforcement of certain of the rights stated in the Universal Declarations. And at that time, and the Convention does set up one of the leading institutions in the protection of human rights, at least in Europe, because there is others outside in other parts of the world, like the American Court of Human Rights, but this is the European Court of Human Rights, which was set up thanks to this convention. Now, the Oviedo Convention was the first legally binding instrument, international legally binding instrument in the field of bioethics. It's lay down ethical and legal principle applicable to daily medical practice, more or less, would say, governing the relation between the patient and the doctor. But it also laid down principle applicable to what was new biomedical technologies. And I will go further on this, but at that time it was new because those were areas, in practice it means genetics, biomedical research and transplantations, where the development particularly technological development, led to increasing possibility to intervene on human life and raise a certain number of concerns on how this could be implemented and the risk and the challenge to the protection of human rights that they could represent. So that was the reasons to address those areas specifically in the Convention. The Convention has no formal link with the European Convention on Human Rights, but it has close, I would say, kinship with the European Convention on Human Rights. It borrows its principle, concept, and terminology to this convention, and you'll find in Article 29 of the Oviedo Convention the possibility for the Court of Human Rights to be asked for opinion on the in relation to legal issue with the interpretation of the convention, of the Oviedo Convention. This possibility have never been implemented, but it shows a link with the Court of Human Rights that is quite interesting in this context. It is a framework convention, so it's established a fundamental principle which needs to be developed, and the convention does provide for that development with additional protocols to the convention focusing on specific areas. And the convention and its protocol form a conventional system. That is to say that the additional protocol don't have an independent life, so to say. They are just complementing the convention. So practically, a country willing to ratify a protocol would have before to ratify the conventions. You cannot ratify a protocol if you haven't ratified first the convention because they are actually complementary to each other. What is interesting is that the conventions contain provisions that represent individual rights, which are directly applicable by a tribunal or by a judge, for example. That's the case of the consent principle that you'll find in Article 5 of the Convention. But it also contains provisions which are requiring member states to act, to take measures to ensure a particular protections of principles that are particularly important. That is true, for example, for equity of access to health, and I will come back on this later on. So you see there's different types of provision, directly applicable or requiring member states to take actions to ensure protection of certain fundamental principles. So there were what I illustrated with these two aspects of the Oviedo Convention are illustrated by the two concerns that guided the development of that convention. First, that the individual has to be shielded or protected from any threat resulting from the improper use of medical or scientific development. And at the same time that the convention should provide, and that is something difficult for legal instruments, to provide for the future. And that is a challenge. So it will provide for a common framework for the protection of human rights in both long-standing and developing areas concerning the application of biology and medicine. And I think this is one of the difficulties of bioethics. It is, at least in the sense of the Council of Europe, like looking at human rights protection in a field that is constantly evolving and elaborating international principles, legally binding, applicable to that field. At national level, it's already a problem if you elaborate a law that becomes obsolete quickly, because the time of enforcement is already long. So at international level, it's even more important to make sure that you are really focusing on fundamental principles that have a sort of a long-standing value. That doesn't mean that their implementation may not need to be developed. I'll just give you an example. The consent principle is certainly not questioned. However, when it comes to biobanks and storing materials for a very long period of time for unknown purposes, I mean research purposes, but not specifically knowing the project, how do you implement that principle? What type of information you give to the persons? How can we consider that the principle of informed consent is respected? What are the conditions for that? So the principle is not questioned, but how to implement it is something that needs to be worked upon. So the Oviedo Convention, as I mentioned, has provisions applicable to medical practice. And I would think that it's relevant to refer to that convention. It is referred to as the European Patient Rights Treaty for that very reason. And the convention does not necessarily create a new principle. It borrowed from the deontology, the medical practice, the deontological code of the medical practice. But it was for the first time established in a legally binding instrument, in an international legally binding instrument. And I tried to organize, to give you an overview of those principles, to organize them around the four main principles traditionally around which traditionally medical ethical rules are organized. That is autonomy, confidentiality, I would rather say privacy actually, which I think is broader and probably more relevant. Beneficence and non-maleficence, one actually articulating with each other, and a principle of justice. So around the principle of autonomy, we're mainly focusing on the consent issue. And the convention is looking at these principles in also specific circumstances where especially where the persons concerned may be particularly vulnerable. The Article 5 of the Convention say that there shall be no intervention on a person without the free and informed consent of that person. I just want to say that this issue of consent is defined in the Convention with regard to particular intervention. That is to say that for each intervention, the situation may be different. And this is particularly relevant when it comes to persons not able to consent, which are vulnerable persons, and the conventions provide for safeguards to be respected, but does not address capacity issue. The convention does not say in which situation a person is considered to be able to consent or not able to consent. It is left to the member state or to the country having ratified the convention. But when, according to national law, a person is considered not able to consent, then there are protective measures that have to be implemented. But this issue of whether a person is capable or not capable may be different depending on the interventions concerned. You may have a situation where a 16-year-old person, which is not, would say, has not reached majority age in most countries, may still be considered able to consent with regard to a particular intervention. So I think this is important to keep that in mind. So the conventions lay down this principle, and also an interesting principle that at the time of the convention was elaborated was really innovative and new, even in countries that have their own legislation in bioethics, like France at the time. The idea that previously expressed wishes have to be taken into account. And it doesn't say that it should be binding, but still, it was the idea that autonomy means you have to get the closest possible to the wish of the person. And in this context, if the person is not in a position to participate in the consent decision, then at least if this person has expressed wishes before, it has to be taken into account. And when it comes to a person not able to consent, it requires that this person be consulted, be associated as much as possible with the decision process, and in certain on certain interventions require that there is a direct benefit for the person's consent. Concerning confidentiality, and I would rather again speak about privacy, well, the convention reiterates the protections of private life, and I think there are two aspects which are particularly interesting, is the right not to know. So the right to know is closely linked with the right not to know, even though some people would say that there is not just such a thing as a right not to know. But in any case, that is an important point. And I would say, in particular, when it comes to genetics and predictive genetic testing or genetic analysis. And also regarding medical secrecy, that is also very important, in particular because it's a pillar, really, of the medical practice. And it's necessary to build trust in healthcare and in the relation with the doctor, which is also a way to contribute to the best interest of the persons. Because if you build trust, you are more prone to have information that are really relevant for the persons concerned, and you may be in better positions to also act for the benefit of that person. Beneficence and non-maleficence, again, I'm going really in general on those principles, but I just want to draw attention on a few articles, particularly Article 16, which is not mentioned here, but it's actually the research part, the research chapter of the Convention, and the protections of integrity of those persons, including with regard to a known risk. And I think this is particularly important because by definition in biomedical research, the situation where there is a direct benefit for the persons participating in that research is very limited. And the risk, by definition, we are in a research context, are often unknown. So this is a particularly important principle, and the Convention laid down a certain number of conditions to be respected. Being aware of that situation, so the proportionality principles, the absence of alternative, the consent that has to be really specific, and I will come back on this later on. So this is an important principle in the context of biomedical research. And, well, respect of professional standards, that's, again, going back to the deontology, and which is true in the medical practice. It was already in the deontology of the medical field before the Convention. The principle of justice is illustrated or acknowledged by the Article 3, which is an interesting principle, which again is one of these principles which actually is requiring the member states to act. This article asks the member states to take action to ensure equity of access to healthcare. So it's not the objective to establish a principle on which individual can rely into individual process or legal process, but it's more the idea of prompting the member state really to take actions to ensure that. What do we mean by equity, which is not equivalent of equality? It means mainly non-discrimination when accessing to healthcare, and it's also taking into account the individual situations. Not everybody has the same needs, depending on the medical status, and that is reflected in this notion of equity. And it's also the idea that it takes into account availability of resources in the country concerned. Protection of human dignity, I think it's a sort of overarching principle, which was not listing in those 4 categories, but I think it's an overarching principle that needs to be emphasized, and which have important consequences, and I would say the current developments make those principles even more important. And I will come back on this. Primacy over of the human beings over the sole interest of society and science. Well, it's the idea again that even though you can have an extremely important benefit of research, the primacy of the human being should prevail. You can have actually benefit for the research and benefit for the persons. So that's why you have the sole interest of society and science. But this is an important principle regarding research. So there is a freedom of research, but it's not absolute. You have to respect human rights in this context. Non-discrimination on the basis of genetic characteristics. That is something which is actually coming from the Convention on Human Rights. You find this in Article 14 of the Convention on Human Rights. But it's adding to the criteria of the Convention of the Human Rights genetic characteristics. No selection of the sex of the embryo. This is an interesting, well, a very important provisions which prohibit that sex selection, except when it's in relation to avoid disease that is related to sex chromosomes. And I think it's interesting to have that. I don't know whether you've been following development, and I don't know whether this is a relevant issue in Mexico, but we in the Council of Europe have identified some situation in some country where the sex ratio at birth cannot be explained by biology. And well, this is a first point. And the second point is that the development in genetics make it possible now to test by a prick on the finger a woman who is pregnant with a very strong reliability around 6 and 7 weeks of pregnancy to know the sex of the fetus. So this is a principle which was elaborated in 1997, but which is particularly relevant, I think, in the light of the development of the technology and science. Non-commercialization of the body and its part as such. Here again, a principle that is extremely important when it comes to organ trafficking, but which is also very relevant in the current context. And I think that there is a particular work and focus on this principle lately with the increasing importance of biological materials. And some discussion have taken place in the Council of Europe on this principle and the possible challenges to that principles, because it's prohibiting payment, it's prohibiting incentives, but it's allowing compensations of cost or loss of income. But there is a gray zone, and how do we define precisely where does payments starts and when compensation stops? This gray zone is a little bit difficult, and there was an agreement that there is a need to assess a little bit better what is meant by this principle and by those explanations. Now I will come to what I call these new provisions on new technology provisions, which are laid down in the Convention, starting with biomedical research, which has a whole chapter. And you see, I'll come back on principles that are addressed by those general principles I've referred to, but are more developed in this chapter. Freedom of research, well, we're back to this primacy of human beings. And the Oviedo Convention was the first legally binding instrument to establish and to affirm such a freedom. But this freedom is not absolute. It's subject to the protection of human rights, in particular those laid down by the Oviedo Convention. I think here you see again these illustrating some of the criteria that are considered to be extremely important to be ensured for the protections of individuals participating in research. Proportionality, that means that even if you have an extremely important benefit expected from that research, you have to assess the proportionality between these benefits and the risk for the persons who may be participating in that research. Voluntary participation, free consent of persons participating in this research. prior independent evaluations of the scientific relevance and ethical acceptability. And here you see the role of what is called in the generic term Research Ethics Committee, responsible for assessing that, because they are responsible for assessing whether the conditions are met to ensure the protections for the participant, future participant. And transparency and international responsibility are not directly addressed, but are more developed in the protocol to the Oviedo Convention on those issues. But I think it's also key elements behind the provisions laid down in the Oviedo Convention. And in that chapter, we have one particular article which addresses a particularly sensitive issue, which is the research on the embryo. And there are two provisions in the Article 18. The first one, which is quite clear-cut, actually it's the second one, it's paragraph 2, which prohibits the creation of embryo for research purposes. The first provision of this article does not take any stance as to the legitimacy of the research on embryo that have not been created for research purposes. But it says that if the law, the national law of the country, allow research on embryo, then they shall provide appropriate protection for that embryo. So it is left to the country concerned to decide whether they consider it possible to proceed to research in embryo that have not been created for research purposes. This is true in some countries, for example, research on embryo that have been created for procreation purposes, but there is no parental project anymore, so the couple concerned is not considering having other children, or there may be different reasons for that. So the embryo are here, kept usually frozen, and in some country it is allowed by law to do research on those embryos. But again, the convention does not take any stand on the legitimacy of this. It's left to the member state. It just requires that if it's allowed, there should be appropriate protection of the embryo. Genetics, which was another topic on which the convention focused. Well, you find again the reference to the non-discrimination, which I refer to for the first time under the protection of human dignity. But there are other provisions that are interesting and also quite relevant, again, with the latest development in the biomedical field. The prohibition of using medically assisted procreations for sex selection of the children. Again, I'm coming back to this development in genetics and also some development, and I've said some also willingness and expression of willingness from individuals also to be able to decide for family balancing, or because the sex of a child is more socially promoted, and they might be willing to act for that very reason. So what the convention says is that you can't use medically assisted procreations to decide on the sex of the fetus. Another provision which is specific to predictive genetic testing, it's prohibiting the use of predictive genetics testing for purposes other than the health or biomedical research related to health issues. Literally, it means that insurance company and employers cannot require from a person who would apply for insurance or would apply for a job to pass a predictive genetic test. The principles behind and the reasons to have this prohibition is the right not to know. And it was felt that there is a disproportion between the challenge to the privacy and the benefit expected from the person requesting this test. Finally, under that chapter, I'd like to emphasize another provision that is relevant for those who may be familiar with the latest development in genetics. It's the prohibition of intervention intended to modify the genome of future generation. I don't know whether you've been following lately the development, but there is new technologies. Well, it's been developed over the last few years, but it hit the headlines lately, which is called CRISPR-Cas9, and which make it possible in a much easier way and a more targeted way to modify genetic characteristics. And it it raised a certain number of ethical issues, in particular because immediately the thought was that maybe we could apply this to embryos and to germlines. And that's created a lot of discussions. And if you see in Nature and those scientific newspapers, and even in, would say, daily newspaper, now you see that the scientific community reacted. And some international high-profile scientists have called for a moratorium on this technology in its implementation or even in the research level on embryo and germlines, considering the ethical implication of that technology and the implication for human being and human species. So you see that something which was adopted in 1997 finds its relevance again with regard to such development. Transplantation of organ is the third area in which the Convention is establishing specific provision. Protection of the living donor. I mean, the focus of the Convention is really on those situations where the risk for the persons is the highest. And even though disease donation raised also some concern, the Convention only addressed the living donation because this is where the risks are the highest. And it established a rule of giving priority to cadaveric donation over living donations. Obviously, living donation is only relevant for a certain number of organs, mainly kidneys and liver to a certain extent. And it prohibits the removal of organs from persons not able to consent, with one exception. The exception is regenerative tissue, like bone marrow, and only if it's for the benefit of brother or sister. So it's a very specific situation, and only if there's no alternative with a person able to consent. But it prohibits removing organs from such a person. Now, just briefly, legal aspect of the Convention. Article 26 of the Convention we're actually limiting the possibility for restricting the rights laid down by the Convention. And the condition is that this restriction is provided by the law of the country concerned, that it is necessary for public safety, for the prevention of crime, for the protection of public health, and this is the case, for example, of contagious diseases, or for the right of others. So you see here that those purposes reflect the purposes of restriction of rights laid down in the Convention on Human Rights. However, the Convention also say that such restrictions are not applicable on certain provisions which are considered to be fundamental. Article 11, non-discrimination on the basis of genetic characteristics, non-selection of the sex, protection of persons not able to consent when it comes to research, prohibition of financial gain, and I should add to that also 2 provisions on transplantation of organs. So, you remember one of my first slides, I said the Oviedo Convention is both a starting point and an achievement. It was an achievement because it was the first international legally binding instrument. It defined a general framework for the protection of human rights with regard to application in biology and medicine. But it does not necessarily contain precise solutions to individual situations and also not to complex questions. I should add to that the Convention does not cover all bioethical issues. There's very little on medically assisted reproduction, for example. It's not because that there was no agreement that those are ethical issues, but we have to accept that there are certain areas where it's very difficult to get consensus. And so it's not because it's not covered by the Convention that it's not relevant and important. It's just that because it was impossible to get consensus. And we're back in particular on the issue of the status of the embryo, which remain an area where it's very difficult to get a consensus at European level, as also acknowledged by the European Court of Human Rights in few cases. So it's provide a framework of principles which to prevent practices that are contrary to human dignity and human rights. And it provides a sort of a set of common basic standards. But it's also a starting point because it aims at being developed further through other legally binding instruments that are the additional protocols. And it also had and continue to have impact on legislation and practices. And I would say also that independently of the additional protocol, it provides a basis for the development of other instruments. And I can refer, for example, to the Convention Against Trafficking in Organs, which is a criminal law convention, which was open for signature on the 25th of March this year, so it's a very new instrument. But the two fundamental principles on which this convention is based to define what has to be criminalized is the consent principle and the non-commercialization principle. So you see that the Oviedo Convention also provides basis for other instruments in other fields than bioethics field, and as such continue to be a starting point, so to say. So which are the legally binding instruments that have been further developed on the basis of the Oviedo Convention, the additional protocols? The first one on the prohibition of human cloning, and most of those instruments are the first and only legally binding instrument in these areas. So prohibition of human cloning, an important instrument which was adopted in 6 months, which is at international level something which was extremely, well, I would say, unexpected, or it was expected because there was a very strong political willingness. But I'm saying that to have an agreement among 47 member states on such an issue means a lot of political willingness and a real consensus on the fundamental value that may be challenged by the practice. Additional protocol on transplantation, biomedical research, and the last one on genetic testing. But you have to know that a fifth one is being developed on the protection of persons with mental disorder with regard to involuntary measures. So the Oviedo Convention has confirmed its value. It has become a reference at national, regional, in a sense of European, and global level. I say this because the Oviedo Convention is one of the rare regional instruments referred to in a UN instrument, and more specifically in the UNESCO Declaration on Bioethics and Human Rights. It proved the timelessness of its provisions. It's establishing principles that make it possible to address future challenges, and this is what we see at the moment. It provides a fundamental basis for national decisions to facilitate the development of national legislations, and it has an important impact on the case law of the Court of Human Rights. So what are the current and future challenges that are encountered in this field of bioethics, where the Convention is really a pillar? Well, we see new development in this field, with new possibility of challenging human rights. I don't want to develop too much, but example of biobanks, I illustrate that with the consent principle and how to implement that when the samples can be kept for periods that are longer than the life expectancy of the persons from whom they are removed. Genetics, neurosciences, information technology, and the combination actually of those technologies. The globalization of the issue addressed, and here I think this willingness of Mexico to adhere to the convention is extremely relevant in this context. Certain threats to human rights due, for example, to the commercialization of healthcare and privatization of healthcare coverage. That is not to say that this, in principle, is a problem, but the way they are implemented may lead to discrimination, may lead to different level, and challenge the equity of access to healthcare, for example. So I was talking about the prohibition of financial gain. So you see I put between quotes donation of organ and tissue and cells, because we don't know whether it's really relevant to donation anymore. With the certain practices we could see at European as well as international level. And also the kind of shift between solidarity to mutuality. That is relevant also for the evolution of the private sector in healthcare compared to the public sector. I put also globalizations versus individualism, but I think to summarize this last point, I would say it's questioning the relation between autonomy, solidarity, and responsibility. And I think it's quite interesting and see how those three principles are actually articulated and how their articulation evolved over time in the practice that we could see. And also what we see is extremely rapid transposition of things that are at the research level into areas that have nothing to do with biomedicine. I'll just give you an example. Electrosimulation of the brain has been something that has been developed, for example, to address severe depression, but it's practice. We could consider it as a clinical tool, but it's still under the research considered to be a sort of a research area. But you go on the internet and you can buy a helmet that is based exactly on the same technology, and which is sold without any protections to improve your gamer performance, or to improve your ability to manage your stress, or to improve your mental capacity to address problems in meetings and so on. So you see, we see these transpositions of things that are emerged in the biomedical field, implemented outside this field, without the safeguards that have been developed in the biomedical field. You may consider that the safeguards are insufficient, but they are absent outside this field. So I think this is also a challenge that is important to be reminded. How to address those challenges? So there are some examples on how the Council of Europe actually tried to address those challenges. Well, to continue the elaborations of the development of the legal corpus, not necessarily legally binding, but to develop legal instrument. Well, I refer to the new additional protocol, but also we develop recommendations, non-legally binding instrument. We are about to finalize a recommendation on the processing of health-related data by insurance companies, so coming back to this Article 12 of the Convention and predictivity. And also we are re-examining a recommendation adopted in 2006 on research on biological materials of human origin, where the revised versions is focusing a lot on the governance of biobanking and the reflecting on the evolution of this sector and the increasing importance of research on biological materials. We are also putting more and more emphasis on the development of tools to facilitate implementation of principle. It's very important to develop legal instruments, but if it's only to have them on a shelf and not being implemented in the field, the value is much more limited. And it's not so easy sometimes to ensure enforcement. I'm sure that I'm talking to convince people in that respect. So having a legal instrument is important, but sometimes it's difficult also for those directly concerned in the field to understand the relevance of the principle and how to implement them in their daily practice. So we have developed some guides, which are not legal instruments, but aiming at, I would say, wording, explaining those principles in a language which is understandable and closer to the practical situation encountered by people in the different fields. Research Ethics Committee, medical doctor in situation where they have to take decision regarding medical treatment in end-of-life situation. And also we're trying, and we will continue to develop that, trying to develop courses for legal and non-legal professionals on bioethical principles, to raise awareness on those principles, based mainly on case law of the European Court of Human Rights, but possibly also national case law. I mean, the idea, this is a project that is not only relevant to bioethics, that has been developed for a long time in the Council of Europe, but we would like to do some kind of a pilot project in the sense that rather than focusing on legal professional, to try to also get on board non-legal professional concerned by those principles. So that is a project on which we are working at the moment. Also to reinforce cooperation activity with the states directly to meet their specific problem. So for example, we organize at the request of states seminars in the country where they can actually invite people concerned, like medical doctor, researcher, institutions, to address practical problem encountered in the country concerned, which may be bound by the convention, but it's just the difficulty of implementing the principle, or just to raise awareness among those peoples about the principle of the convention. And we're also trying to reinforce synergy and link between the Council of Europe and other intergovernmental organizations working in this field. This is not new in bioethics. It's been going on for many years, including during the elaboration of the conventions. But we're trying also to develop that, including at global level with UNESCO, WHO, and the Council of Europe is a member of the UN Interagency Committee on Bioethics, which includes, well, WHO, UNESCO, UN agencies, but also the European Union, the European Commission in that case, the Council of Europe, the OECD, and we meet once a year to try to develop synergy, to develop cooperations, to avoid duplications, to work together. So that's also a way to contribute to that objective. Now, as a conclusion, regarding the Oviedo Convention, well, I hope I convinced you that it was both an achievement and a starting point. It is considered to be the European Patient Rights Treaty, And it has become a fundamental reference at global level as well as regional, obviously, but global level I think it's an important point. It has profound impact on legislation and practices, and I have just here quoted some important persons that have participated in the conference that we organized in 2009 for the 10th anniversary of the entry into force of the Convention. Jean-Paul Costa was at that time the chair of the president of the Court of Human Rights, which actually emphasized the importance of the Oviedo Convention for the Court of Human Rights. And we could acknowledge that in the case law of the court on bioethical issue that is building up. And if you are interested, we have a report on the analysis of the case law of the court on bioethical issue. And the court also had on its website fact sheets by topics, which are updated regularly and are quite interesting. Well, Professor Jose Trontel from Slovenia made a point which to me illustrates the idea of a framework providing a basis on which member states or country concerns can develop their own legislations by saying it provides an ethical framework within which it is now possible to work safely and in confidence. And I think also the last reference is interesting because it's sending back to the idea of mutual responsibility and solidarity. It's Professor Sadek Belousif, who was a member of the National Ethics Committee in France at that time, saying that the Convention illustrates the willingness to combine trust in scientific progress and protection of ethical values, determining a new form of responsibility. I think for me it's very important to perceive protection of human rights and progress as working together and not in opposition. It's extremely important to address human rights protections to promote the progresses which mean the benefit for human beings. And I feel sometimes that they seems to be opposed by some people who perceived protection of human rights as, limiting progress. But for me, progress means progress for the benefit of human beings. And if you make sure that any abuses and people are protected from any abuses, they are more confident in the development and science, and it's contributing also to build trust. So independently of the fundamental value of the protection of human rights, I think it's important to consider that protection of human rights is a necessity to promote progress in science and technology. And, well, I ended up with a reference to Mexico and to the ratification. I mentioned that ratification is the formal acknowledgement, but it's also a commitment to implement the provisions. And Mexico asked the Committee of Ministers to be invited to accede to the convention in 2002, which it was granted. And if Mexico accede, which is the term we use for ratification if it's a non-member state, to the Oviedo Convention, it will be the first non-European country to become party to that convention. And I think this is particularly important also in the light of, we say, the importance of bioethics in Mexico as certified by the involvement of Mexico in the discussion in the Council of Europe and in particular in the Committee on Bioethics. So I think that was all I wanted to tell you about the convention, and you can find more information on our website. And I'm also available if there are some questions now or after, even by emails. So thank you for your attention. Yeah.
I would like to ask you what are the main topics that have been developed in Europe after the Oviedo Convention. You presented lots of topics that are addressed by the convention, but what of those topics do you consider are better developed in Europe after the convention?
What do you mean? Which are the most relevant ones? Yeah, I think one of the I think that there are developments in all these areas that are actually relevant. If you would consider biomedical research, I think biobanking, I would put biobanking under that heading, and it's taking a dimension that really calls for examination and discussions. There's a lot of progress is expected from biobanking, but there is also a certain number of risks attached to it, and it's important to address them. I think it's equally true for genetics. I mean, it's been exploding really, literally. And we still also talk about globalization, but the transborder flow of material data. So you have a lot of issues that are really relevant. I would say transplantation as well, even though it's a more traditional field, but the shortage of organs is increasing. Life expectancy is increasing as well. So everybody is confronted with situations where the demand for organs is increasing, and the chances to address them, really to meet the request, are limited. So probably there is a need to not only to promote organ donation, but also promote actions to prevent people from being in need of organs. But what I would like to emphasize through your question is that one of the things which is important for an organization like the Council of Europe when addressing issue is to see whether this is relevant, in particular relevance to human rights perspective, which is the main objective of the Council of Europe, whether there is a chance to get an agreement. I'm sorry to be so pragmatic, but it's a reality, and there are certain areas, beginning and end of life are very difficult areas. That does not, as you've seen with the guide, prevent from addressing them, but we have to be aware that in certain areas it's difficult to get agreement on a legal instrument. That doesn't mean we don't address it in another perspective. And second, it's the added value of the work done by the Council of Europe, which is also an issue. There might be other organizations who might be better placed to address this issue. And we are trying to develop those synergy. So sometimes issues are relevant at global level, but it's acknowledged that it may be easier to reach a level of agreement at a regional level that could be used as a step for the global level. So you see the reasonings behind the decisions to address one particular topic. It's not only based on the ethical relevance, it's also based on other criteria. And the type of answer or the way to address those issues may vary depending on those different criteria. Sometimes the Council of Europe is also a forum, and you could publish a report analyzing the different issues, raising some concerns, calling on principle that may not necessarily be a legal instrument, but may contribute to the general discussion on those issues. So there are different ways to contribute to the discussion and the way to address those issues. I don't know whether I answer your question through this, but I think this is important to keep that in mind.
Thank you. I would like to ask you, you were mentioning before that part of your work is go to the countries, requested by the countries to have seminars there in location to help them think about certain issues that they're worried about, that they're concerned, and that are practical. Could you have at the top of your head some example about a practical issue that has been popping up lately?
Well, the origin may be different, very diverse. I can give you one example. In Moldova, the government was enacting a new piece of legislation, in particular addressing organ trafficking. And they asked to get a seminar organized because they wanted also to get some support in communicating around this new legislations to people concerned. So we organized a seminar with our colleague also from the transplantation sector to raise awareness on the principle laid down in the Oviedo Convention in its protocol. And so there were technical presentations. There were also presentations by experts about the implementation of that legislation in their own country. And the seminar, the participants in the seminar were mainly people from director of institutions or responsible for transplantation in hospital. And there was a press conference also because I think there was a wish to raise awareness on the willingness of the government to really enforce those principles in their own country. So that was an example of motivations to organize that. In Georgia, there was another situation where there was a bill on biomedical research, and Georgia asked to get an expertise on the bill by the Council of Europe to assess whether the bill was in line with the principle laid down in the Oviedo Convention and its additional protocol. And once the expertise was finished, then they asked to get a seminar to present the outcome of this analysis and exchange with the researcher, people involved in biomedical research, ethics committee. So we organize something. It's much easier if you're in the country to invite all the people who may be concerned by the topics. Whether if we organize something in Strasbourg, you could have maybe 1 or 2 persons coming. But the idea is really, that's the type of things that was organized. We also organize regional meetings. We have done so last year on genetic testing, and we had a representative of 23 different countries, but people in the field, like responsible for genetic testing in institutions. And the idea was to exchange practices, difficulties of implementations among the different states. So it was a very practical approach to the principle. And it's also networking. It's also trying to discuss, or maybe in one country they have developed certain tools to address certain issue that may be relevant for other countries. So the modalities and the motivation may be different, but the idea is that it's always a request from the country and it's always tailored to the needs of that country. But the needs may vary. The reason why I refer to this instrument as becoming a reference at global level, it's again because this instrument is a reference at UN level. Now, that doesn't mean that everybody agree with all the principle, and that is true also for Europe. I mean, you have some countries who have some reservation regarding certain principles. But for me, it's an acknowledgement of the universal value of those principles. And actually, if you look at the Declaration on Bioethics and Human Rights, you find a lot of correspondence between the provision of the Convention and the Declaration. So again, the difficulty you can encounter at global level are to a certain point the same. You have the diversity of view. However, the practice and what country wish to promote in their legal instrument is sometimes different as well, including on issues that are a little bit sensitive on this. So how to promote that, it's not really, I wouldn't say it's our task to go, but it's a fact, and we see that. By the way, I was reading on my way here decisions of the American Court of Human Rights, which does refer to Article 18 of the Oviedo Convention. So you see that it is also a reference for institutions that are not European institutions and are human rights quite important institutions. So, and through the different conferences, the different events that look, the Global Summit on National Ethics Committee or the World Congress. I mean, I'm referring that not by accident, but you were well aware of this type of event because Mexico organized the last one. And you also exchange on those provisions and principles. And I think this is a way also to raise awareness, but it goes vice versa. It's also important to be aware of the discussions and the concerns outside Europe in relation to those, because those issues are not regional issues. The way to address them may actually be have some kind of regional, but even among the 47 member states, the situation is extremely different. And I would say the values are the same. The hierarchy and the priority are sometimes different also because of the situation in the country. But I don't think that the values and the universal value of the principles are questioned. So it's I wouldn't call it a passive way of promoting it, but I think it's acknowledged by the way we communicate, by the fact that it's actually relayed by experts themselves on what represents this instrument. And again, the fact that you don't find a lot of regional instruments referred to in UN text. I don't know whether this is the only regional instrument referred to, but I know that this is one of the rare ones. So in itself, it means something, but... Sure.
Thank you very much for this eloquence in this conference. And I would like to ask you, how do, in your experience, the Oviedo Convention influence the practice of institutions, the public policy and the government inside?
Okay. Well, I guess Professor Javier Arias, who will be also speaking about this, might actually illustrate that more precisely. But we did a questionnaire on the occasion of the 10th anniversary of the entry into force of the Convention to assess that influence on legislation and practices. I would consider legislation as policy, as you, even though that may not be only legislation's policy, may be a little bit broader than that. And we found out that there was none of the countries where it hasn't had an impact, even in countries that have not even signed the convention. And the impact is true, well, there are only very few countries that have actually bioethics legislation. France, I think, to my knowledge, is the only ones to have a so-called bioethics law, which covering different perspectives. But in most countries, you have health legislations, you have procreation legislation, transplantation legislation, and almost in all these different fields you see an impact. And also an impact on the practices and the codes that could be developed by professionals. So I cannot cite exact, but we do have this reply to this questionnaire, and we still have the recording of that conference. So if you were interested, you can have some practical example of that. But we have we have acknowledgement of that impact, both in legislation and in practices. And well, I can give you a concrete example though. When we elaborated the protocol on genetic testing, Germany was working on its legislation on genetic analysis. And even before actually the protocol was finalized, the German legislation took on board provision of the protocol, word for word. So Germany has not ratified the convention. So you see that, and it's interesting also to understand that when you elaborate a legal instrument, it's not only the outcome that is relevant, but the process of discussion, which is nurtured also by the discussion at national level. So what country discuss at national level is contributing to the discussion at European level, and vice versa. So it's a continuous process. You can't say it's only when the instrument is finalized that it has an impact. The just fact of raising this issue, discussing it at European level, means that delegations are aware of the different concerns, aware of the work done by National Ethics Committee, provide a very strong basis also. And that's usually a lot of background instruments are coming from a National Ethics Committee on those issues. So this process in itself is already having an impact and hopefully continues afterwards.
Do you have any discussion about elderly population in the Oviedo Convention? Because it's, I think it is an issue, a big issue regarding ethics, and I was thinking on informed consent for the elderly is just as fragile as the kids. So is there anything going on about that?
Well, there is already a recommendation on the right of elderly persons, of older person actually it said, and it was developed by the Steering Committee on Human Rights, which is a committee under which the Committee on Bioethics is working for certain topics, not about the convention, but on other topics. So they have developed a recommendation on the right of older person. So this is a human right issue. Now, particularly in the field of biomedicines, as you pointed out, it raised some specific issue. Not all older person are vulnerable person, I would argue personally. You have younger person who are vulnerable person as well. But I think that when you are looking, for example, at the guide on end of life, obviously, not all the persons concerned are old person, but it's particularly relevant in this context. I can give you another example which was raised and which is actually discussed in the context of the new additional protocol concerning person with mental disorder. Because there is a category of person, involuntariness is defined by the fact that the person is objecting. But you have persons who do not object, neither consent. They're just, you just give them something, they will do it. Or you ask them to do something, they will do it. And those are people, demented persons, or often older person in that situation, which is a situation of concerns. For the moment, I don't think this category of person will be covered by the protocol. It has to be seen, but it's certainly a point that is raised that those persons need specific protections, and that the protocol may actually provide a basis for that. Well, we are in the protocol is going to be made public for public consultation, by the way. So I take this opportunity to raise awareness among you, but I'm sure this will be conveyed by your representative in the committee. But this is this point was raised. These people in this gray zone, they're not objecting, they're not consenting. How should they be treated? And they need protection, that's for sure. So in this context, yes, but there was no specific dedicated work to older person. Because here again, you have a whole diversity of situation. And vulnerability may not necessarily be attached, even though you may argue that older person may be in general, in majority, more vulnerable. But you also have other category of persons and particular situation. But those are two examples where older person were particularly attention was drawn on this category. But I can send you the link with the recommendation on the right of older person.
Thank you very much.
It was a pleasure.
Laurence. It was superb, beautiful, and excellent.
Well, thank you. Hopefully, I hope it was
presentation.
informative.
We are very happy. I must tell you that this is the first of another activities that we are going to have
Mm-hmm.
in this week, and that I hope that, as you said that in your presentation, that Mexico will join the Oviedo Convention.
Well, this would be
With that
certainly an
action,
extremely important and significant step for the Council of Europe as well.
We are working so hard, and I hope that this week will be very important for Mexico. Your presence here will support all the expectations that we have that Mexico will be the first country in adding to the Oviedo Convention.
Well, thank
you. I would like to give you this.
Oh, thank you very much. That's very kind of you. Thanks. Thank you for all of you. Oh, thank you very much.
I'm going to give another information. Mañana tenemos el seminario en el Instituto de Investigaciones Jurídicas y la Comisión Nacional de Bioética sobre el convenio, la Convención de Oviedo, y posteriormente el jueves 21 será en la Academia Nacional de Medicina el evento que conjuntamente llevaremos a cabo para ver los beneficios, la perspectiva que tiene la Convención de Oviedo para nuestro país. Es así que podremos ver desde luego esta presentación en la Comisión Nacional de Bioética, mañana ver el espectro que tiene, la importancia de la perspectiva jurídica y de la participación de otras instancias académicas dentro de nuestra máxima casa de estudios, y posteriormente el tema en la Academia Nacional de Medicina analizado desde su perspectiva biomédica, que creo que es un tema que arropa y proyecta mucho a la Convención de Oviedo en el desarrollo de la medicina en nuestro país. Así que muchas gracias, Laurence, y gracias a nuestro público por participar el día de hoy en esta magnífica conferencia en el marco de las videoconferencias de CONBIOÉTICA 2015. Muchas gracias.
Muchas gracias.